I should say at the outset that despite malicious rumours that circulate around here from time to time, I wasn't actually in the GPO in 1916, nor was I there to hear the proclamation read out. From a conversation we had last night, I was hoping to be able to say that this university has a special relationship with the proclamation itself, the actual document itself. It was printed very quickly in Liberty Hall the night before the rising on Easter Monday, and even with by the standards of the time, the equipment they were using was very primitive indeed. And we know the names of the three people who were responsible for printing it, and one of those is a man called William O'Brien, who was then a lecturer in French in University College Dublin. And he served in the Rising the following day, actually, on Stephen's Green. He spent time in Wales in prison for his troubles. And then the following year, 1917, by which time he had changed his name to Liam O'Brien, he was appointed to the Professorship of Romance Languages here in this university, a post that he held until 1958. And in fact, he lived a long and active retirement after that and was a very frequent guest on the Late Late Show throughout the 1960s. But as I say, we may have that connection with the proclamation, but Mary Harris tells me last night there is a possibility that there were two Liam O'Briens, and that he may not have been, in fact, the person who actually printed the proclamation after all. So that's something for somebody to check out, and hopefully we might be able to claim some degree of ownership of it. However, I have been given, as I say, a very lengthy topic, or a very large topic to address, which is penal policy, which, of course, in itself is a huge area, and a century is a long time, and 20 minutes is a very short time. So I just want to, if you like, take one small, or to address it in one very narrow way. And the subtitle that I took was Managing the Inheritance, and all I want to do really is to explain what I mean by that. Because when we achieved independence in 1922, we inherited a body of criminal justice legislation that was quite progressive and enlightened by the global standards of the time. There's no doubt about that, and indeed even by some global standards of today. And if we are to look at the origins of that, well, 1916 actually would not be an appropriate place to start. The best route of title, or a much more appropriate route of title, would be 1906, January 1906 to be exact, because in that year you had the general election, which led to a landslide victory for the Liberal Party at Westminster. And what happened over the next 8 years was quite extraordinary, really, and of course it's very well documented, in that the body of legislation that was passed, not just in the criminal justice field, but also in the entire area of social policy, really shaped the society that we have had in both jurisdictions since then. It's rather ironic that the Prime Minister who was elected in 1906, Henry Campbell Bannerman, is probably the least remembered Prime Minister of the 20th century. He wasn't very effective, as one historian said. If his wife and his health hadn't been against him, quite a lethal combination, he might have been a bit more successful. But he did, of course, have a uniquely talented cabinet, including Asquith, who succeeded him in 1908. And they proceeded to enact a body of law which in some ways is seen as the foundation of the welfare state. Now, again, social historians such as Asa Briggs have drawn a distinction between the welfare state, which is concerned with universal provision, and what he called the social service state, where provision is targeted at those who need it, and this was certainly more of a social service state. But just leaving aside criminal justice legislation entirely for the moment, I mean, if you just look at the roll call of legislation that was enacted in that period, 1906, let's say to 1909, the Workmen's Compensation Act, the Trade Disputes Act, the Children Act, which we'll come to, the Old Age Pensions Act, the establishment of labour exchanges, and many other things besides. But in the criminal justice field, it was equally significant, because that was the era in which you had enacted the Probation of Offenders Act of 1907, which is still on the statute book in this jurisdiction unchanged. The Children Act of 1908, the Court of Appeal Act of 1907, and the Prevention of Crime Act of 1908, which was responsible for the establishment of borstals, among many other things. So this legislation, as I say, was enacted during that short period. It's actually quite difficult to discuss. There's a great deal of research done on the more social welfare legislation that was passed. Little enough, actually, on the criminal justice legislation, like the pieces of legislation I have mentioned, because they were kind of nodded through Parliament. At that time, the Liberals certainly had a majority in the House of Commons. Of course, the Conservatives had a massive majority in the House of Lords. All of this was happening before the Parliament Act of 1911 removed the veto of the House of Lords over Commons legislation, and therefore that kind of legislation wasn't going to get through unless, in fact, it had bipartisan support. But that, as I say, was a very crucial moment in the development, if you like, in our criminal justice history. Just to say one other thing about it, I suppose, and again, there's a lot of kind of analysis of this done by people like David Garland in some of his early work. It was, I suppose, influenced very strongly by developments in the field of criminology. This was an interesting area where theory began to impact upon practice, if you like, because throughout the 19th century, the great development was in positivism. Positivism was about the idea that just as one could understand the physical world around us by scientific methods, so it was possible to understand the social world around us by scientific methods, measurement, analysis, data collection, and so forth. And criminology developed in the late 19th century as a discipline which was based on the idea that you could understand human behaviour, including criminal behaviour, by adopting scientific methods. And it resulted in a far greater focus on the individual offender as opposed to the crime. Prior to that, criminal justice policy was based on, if you like, a notion of rational choice or free will, the idea that people were responsible for their actions. The positivist approach changed all of that. And this was an interesting example of where, if you like, a body of fairly recent academic research, if you like, began to impact quite directly on the legislation that was passed, because the main pieces of legislation that I mentioned, like the Probation of Offenders Act, was based on the idea that we should look at the individual offender rather than at the crime. That then, if you like, was what we inherited in 1922. It wasn't all that we inherited in the criminal justice area. For example, by the mid-19th century, capital punishment had been abolished for everything except murder, and even then it was rarely implemented. Most offences were governed by maximum sentences rather than mandatory sentences, which meant that judges had discretion in the sentencing of virtually every offence except murder. And, of course, as well as that, two other pieces of legislation had been passed in the late Victorian and early Edwardian eras. One was the Criminal Evidence Act of 1898, which for the first time, believe it or not, allowed an accused person to give evidence, sworn evidence, in their own defence, but that did not apply to Ireland. There's still some historical debate as to why it didn't, but it didn't. And also the Court of Appeal Act of 1907, for the very first time, allowed people to appeal against their conviction by a jury and to appeal against the severity of their sentences. Again, that did not apply to Ireland, strangely enough, and there is some debate about why it didn't. So that was the situation then that we inherited in 1922. I want to ask the question, how did we manage it? Well, we preserved it, let's put it that way. We didn't fritter it away, we preserved it, but that's about all we did with it. We kept the Probation of Offenders Act. There's rather like this notion of the acquis communautaire in European law. I mean, we acquired all of this. We didn't have to keep it, but we did. And not only that, but we added to it. It's very often said, I think it has been mentioned already in this conference, that our transition to our, if you like, becoming an independent state was more a transition than a revolution. So certainly we added to it, because no sooner had we got independence than not only did we adopt all the legislation that I've mentioned, but we also lost no time whatsoever in adopting the Criminal Evidence Act of 1898 to allow accused persons to testify in their own defence. And we also introduced a court system, the Courts of Justice Act of 1924, which introduced a Court of Criminal Appeal, which we still have in a slightly different form. But what happened after that? Well, the point I'm just trying to make is this, that the legislation that was enacted by the Liberal government, let's say from 1906 onwards, was very much based on the notion of treating defendants and offenders as individuals. It was moving away from what we might nowadays call an actuarial system, dealing with people as individuals. To what extent have we, if you like, developed that? And I suppose the essential point I'm making is this, that we certainly have maintained that policy of individualisation very strongly throughout the history of the state. Insofar as procedure is concerned, we have been very, very active and very dynamic, mainly at judicial level, in developing procedural rights, but we have been, I'm afraid, far more lacking in developing substantive rights in terms of, if you like, making substantive changes to the penal system, to the way in which we deal with offenders. We didn't, I should say just in passing, that there has been very little for the first, I suppose, 80 years, well, the first 65 to 70 years after the foundation of the state. We certainly didn't add at all, Harley, to the, if you like, body of legislation that we, as far as penal policy is concerned, that we inherited on independence. Yes, we abolished the death penalty for all practical purposes in 1964. We we introduced community service in 1983. That was pretty much it, until far more recently when we have been becoming a bit more dynamic. All of that, I might add in passing, was based on the idea that we really didn't have a crime problem. After all, if you go back to the prison statistics for the late 1950s, you find that we very often had an average daily population of less than 400 people. But of course, we now know that a lot of that was quite fictitious. We know, for example, that there was a great deal more serious crime happening than was ever reported, was ever recorded, or was ever dealt with. Most of that crime I'm thinking about is in relation to child sexual abuse, because an awful lot of what has been going on in our courts over the past 15 years or so, and I have been involved in a lot of it myself, is dealing with historic cases of child abuse, so that we have been compensating in recent years for past failures. So in all probability, the amount of serious crime that was happening in this country was far greater than anybody ever imagined in the 1940s, 50s and 60s. But leaving that aside, as I say, we were acting under the impression that we didn't have a serious crime problem, and therefore we could be quite complacent about not making any significant changes to our system. What I want to, the essential kind of, I suppose, point that I was going to make about maintaining this individualized approach towards criminal justice is that we have done that and continue to do it at a procedural level. And there the Constitution has been very important, and the way in which the courts have interpreted has been very important. It's very often said that we had a constitutional revolution in this country in the 1960s. But when people talk about that, they talk about cases like McGee, or indeed like De Burca that Conor has mentioned, and various others, and that those cases brought about a revolution of sorts. I think what those cases did, I don't wish to underestimate their importance, but what they did was they accelerated social change. They weren't necessarily solely responsible for causing it. Many of the changes would have taken place over time anyway, even if the courts had never, in fact, made the decisions that they did. After all, if you want an example of that, in April of 1983, the Supreme Court decided that it was not unconstitutional to outlaw homosexual acts between males, even if they were consenting and depending and irrespective of age. But yet, 32 years later, we were introducing same-sex marriage. Okay, it took 32 years, but it happened. And it was very important that cases like McGee did occur. As I say, they accelerated social change. But there was a revolution, what was very important, that was a procedural revolution. Because governments might not care very much about whether we use contraception or not, or whether there are women on juries or not, but they do care very, very much about power and about maintaining power. And you had a whole series of very vitally important decisions, starting perhaps with East Donegal co-op case, the Garvey case, and various others, where the courts began to insist that power should be exercised in a particular way. In the East Donegal co-op case, you have that very important short statement by Mr. Justice Walsh, writing on behalf of the Supreme Court, where he says that the presumption of constitutionality means that all procedures and that that administrative decisions will be taken in accordance with constitutional justice. And the courts effectively, through cases like that, right down to the present day, have been changing the nature of power. Before those cases, power was seen as a privilege. They turned it into a responsibility. And therefore, that of course came into was very important in the criminal justice system as well. So that today we have in this country probably a stronger due process body of law than virtually any other country in the world. If you look at the extent to which we have judicial review applications in this country from people constantly challenging decisions of the Director of Public Prosecutions, challenging the way in which they have been treated in the lower courts and so on, there's a constant stream of that case law, and it is usually successful. The courts have enforced a very, very high set of procedural standards in the way in which people are dealt with, both as defendants and indeed as offenders. The other way in which we have maintained an individualized approach has been in the philosophy of punishment that we have adopted in this country, where the courts have said, as courts now pretty much throughout the common law world outside of America are saying, that the overarching principle of punishment is proportionality, that a sentence must be proportionate to the gravity of the offence. Here in this country, we have gone two steps further. First of all, we have said that it must be proportionate to the gravity of the offence and the personal circumstances of the offender. And secondly, we have said that that is a constitutional imperative as well as a common law imperative. So we have that, if you like, element there as well. And those two things, I don't wish to underestimate their importance. They are very important because they are ensuring, if you like, adherence to the rule of law, first of all, which is embedded in the Constitution and which is very much a common law principle. And it does mean, therefore, that people can be assured, if you like, of a strong level of procedural justice. And it also means, I think, it's true to say, that the proportionality doctrine that we have developed in relation to sentencing is far more friendly, if you like, towards the individualization of punishment in individual cases than it would be in several other jurisdictions. But I suppose to end with a more negative note, compared to all of that, we have been quite bad, if you like, at developing more substantive both rules and institutions within the penal system. I talk about the penal system here more in terms of how we deal with offenders rather than defendants, at a number of different levels. First of all, we have not been at all dynamic in trying to tackle the causes of crime. I think probably the great tragedy of the Celtic Tiger era is that we made no effort whatsoever to tackle the underlying causes of crime. One of the things I thought was quite ironic is that one of the great developments, which is seen as a great development of the 1906 to 1914 era, was that in 1906, for the first time, they introduced school meals for children. I remember in the early 2000s, when the Celtic Tiger was roaring, being at a conference like this and talking to a teacher in Dublin who was teaching in quite a deprived school, or a school in quite a deprived area, and he was saying how the fact that there had been a slight dip in the economy at the time, I forget what happened, and the very first thing they did was to remove school breakfast, which means that, of course, the attendance of children plummeted. That is the kind of thing that we failed to do. We failed, if you like, to use our wealth to if you like, tackle what would undoubtedly be a significant cause of crime. And I'm, of course, aware of the controversial, or as some people would see it, the controversy over the relationship between poverty and crime, but there's certainly a strong correlation there. And I suppose the second thing that we have failed to do, specifically coming into the area of criminal law and the penalty and the sentencing system in particular, is that we have probably failed to, first of all, deal with imprisonment in terms of the nature of the prison institutions that we have, which until recently have been quite appalling, and they still are. We have failed to deal with, to provide, if you like, a more extensive and a more effective set of non-custodial penalties. As I say, we're still very much stuck in that 1906 era in terms of the options that are available to us. And I suppose we've also been thank you, failing to deal with how we deal with young offenders in particular, and I'm concerned in particular about how we deal with the young adult offenders. There was some degree of celebration, because I don't think I'll be kind of going into what Ursula will be talking about in a moment. There was some degree of celebration just before Christmas when it was announced that St. Patrick's Institution was going to close down. But in fact, again, it's the old story, nothing really has been put in its place. So if you were to sum up the balance sheet, therefore, we have managed the inheritance very well, I would think, on a procedural level by giving people individual rights, but we haven't managed to do it very well in matters of substance. Thank you very much.